Good evening, folks, and welcome to Prince George's County's presentation of the Family Law Seminar. My name is Bruce Desimone. You should already have business cards and pens with my name on it. You can reach me at mdlawadvice.com on the internet or at 301-262-6000. My extension is extension 4. Also, if you do a search for my name on the internet, it's Bruce Desimone, D-E-S-I-M-O-N-E, and you're going to find a different phone number, 301-918-0034. It rings in the same office, I promise you, 301-918-0034. I am a practicing attorney here in Prince George's County. I actually grew up here in the county. I attended and graduated from Apple Grove Elementary, yay. Went to Lord Baltimore Middle School, which was a junior high school in my day. Went to and graduated from Friendly High School, go Patriots. Graduated and matriculated to Prince George's Community College, ultimately to the University of Maryland at College Park, Harvard University, and I completed my Doctorate of Jurisprudence, which is a hotsy-totsy fancy name for a law degree, at the University of Maryland. I've been a practicing attorney since 1993. I've taught these classes first as a volunteer, but now they actually pay me to teach these classes. And I've taught these classes since the inception of the program, which was probably about 10 or 12 years ago. So I'm very familiar with what's going on today. I practice here in the county, in Bowie, and I primarily practice family law, criminal law, and contracts. I am a trial attorney, so I'm able to handle all your litigation needs. I have 7 other partners, and if we are not able to assist you in resolving your legal problem, we can provide you a referral. I always have a free initial consultation. You are welcome to contact me through the phone and set up a free appointment, and I'm happy to help you with any legal needs you might have. Now we're going to have an overview of what's going to be discussed today. I'm going to start with a summary, and then I am going to utilize the packet that you have been provided. We're going to walk you through a contested divorce case, and the reason we're going to walk you through a contested divorce case is very simple. A contested divorce case includes custody, child support, property. You may have some or all of these issues relevant to you, but indeed, somewhere along the line, we will fill in any gap and answer any question that you might have. Now, first I have to tell you, I like to talk about things as simply as I possibly can. I like to talk about things not in a legal situation. I talk about sports, and I talk about cars, and I'm going to start out by talking about a peanut butter and jelly sandwich, and I'm going to explain to you the court process. So let's start with some terminology, and I'll do that in just a moment. When you begin a family law case, when you begin any case, the person who begins the case is the plaintiff. Nobody wants to be the defendant. Nobody wants to be the defendant because of what you see on television. The defendant in a criminal case, might go to jail. Unless, of course, F. Lee Bailey or somebody else, Perry Mason, is defending him. Then, you know, Perry Mason's client never goes to jail. In a non-domestic civil case, the defendant might owe the plaintiff money. For example, you might have lent your neighbor $100 and you sue your neighbor. You are the plaintiff, your neighbor is the defendant. The neighbor in that case may owe you money. Nobody wants to be the defendant. It's not true in a family law context. In a family law context, the plaintiff is simply the first person to file. The defendant is the second person to file. Relief can be provided to the plaintiff. Relief can be provided to the defendant. Now, I say that because many times there's a case out there. You filed a case 2 or 3 years ago, and you were the defendant. Now you need new relief from the court, so you file a new case. You're the moving party, so you think, oh, I'm the plaintiff. No, you're not. And you need to be very careful, because you could simply, the court could say, the plaintiff's relief is denied, but you're the defendant, and you're the one making the motion. So you need to be very careful. All right. Now let's start with a complaint. Let me grab my pleadings. You have a packet, and of course if you're watching this on videotape, you probably don't have a packet in front of you necessarily. This is the complaint for an absolute divorce. It is a packet that is available online. You can get it by going onto the Prince George's County government website or the Prince George's County judicial website. You can download it free. You can come to the courthouse and get it. Some agencies, and I don't quite understand this, some agencies give it away free, others charge $2 or $3 for it, but it's available to you. Your packet starts with 4 pages of instructions. Skip those, because I'm here to talk to you about this. Those are designed, this packet, by the way, was put together by judges and attorneys in an effort to help pro se litigants. Pro se is one of those fancy legal terms. It just means a litigant, a plaintiff or a defendant, without an attorney. You should start where it reads Civil Domestic Case Information Report Form. Here's the first and biggest mistake that people make. This is not a pleading. This is a statistical form. You must fill it out. But it is merely a statistical form. People think that they're getting relief from this. They are not. The courthouse uses it for statistics. That's it. If it's a 2-page form, so if you flip those 2 pages, you come to the first form that we are really going to talk about today, and that is the complaint for absolute divorce. If you're on the internet, it's Domestic Relation Form 20, and it even says that under the title. All right, now let's start out with you're filing a new complaint. But that's technical. Let's pretend for just the briefest of moments that we're making a peanut butter and jelly sandwich. You put peanut butter on one slice of the bread, you put jelly on the other slice of the bread, you put them together, and you move on to the next step. The next step in making a peanut butter and jelly sandwich is merely eating the sandwich. Now we're going to use that analogy to talk about the complaint. You're going to fill out a complaint, and we're going to go through in a moment and go through this entire complaint. But the overview is this. You're going to fill out the complaint, and you're going to file it with the court. That's your notification to the court that you want relief. Then the complaint gets served on the defendant, and we'll talk about the technicalities of that, and the defendant has the opportunity to answer. When the defendant answers, you now have a peanut butter and jelly sandwich. You're pleading your request for relief and the defendant's answer. You put them together and we go to the next step. The next step would be a scheduling conference. Now that's the general overview. Let's back up a little bit and begin talking about the complaint. The complaint, again, is the complaint for absolute divorce. The complaint for absolute divorce starts out with your name and address. You are the plaintiff because this is a brand new case that we're filing. It asks for the name and address of the defendant. The name and address of the defendant, in all likelihood, must be different from your address. If you are living in the same residence, you can get a divorce, but only in limited circumstances. Only if there's adultery or excessively vicious conduct. So for the most part, if you don't have a different address than the defendant, you need to consult an attorney. It's very complex. Additionally, you can handle this case. You're legally permitted to handle these cases by yourselves. You're allowed to do that. That's partially why we have the forms to help guide you. But unless you have a short-term divorce, certainly under 10 years, and no real property is houses, timeshares, things like that, and no children, you're going to make a mistake by not having an attorney. Doesn't have to be me, but you should have an attorney. Now, if you have a simple divorce, you've been married 2 or 3 years, you've always rented an apartment, your spouse lives in a separate place than you, you've divided up all your property, then in that event, you can use these forms and get yourself a divorce without the necessity of hiring an attorney. If you make a mistake, it's no problem. It's just going to cost you a little bit of time. You might have to come back a second time or a third time. You might have to take off of work, but you're not harming yourself. You're not cheating yourself out of thousands of dollars. You're not harming your children. But if you own a home, if you have children, you really should be hiring an attorney. So now we continue on with the complaint. The first line says, my name, representing myself, I am married to the defendant, and I got married on such and such a date. And you list that date. And you tell the court where you were divorced, where you were married, the location, and whether it was a civil or a religious ceremony. Because Maryland must have jurisdiction, doesn't matter where you were married. You could have been married overseas, you could have been married in another state of the Union, Nevada, Kentucky, it doesn't matter. But because Maryland has to have jurisdiction, one of two things has to be true. Either you have to have lived in Maryland for at least a year for a divorce, or the grounds for divorce have to have occurred in Maryland. So for instance, if your spouse and you both live in Virginia, but your spouse came here to commit adultery, you could then in that event get a divorce in Maryland. If you are not filing, because I told you that this would encompass everything, but if you're not filing for a divorce but just for custody, if the child is newly born and lives in Maryland, that's fine. He can be a day old or she can be a week old, and you can file here in Maryland. Maryland would have jurisdiction. If the children have are older than 6 months of age, they must reside in the state of Maryland for more than 6 months for Maryland to have jurisdiction, unless there's an emergency. If there's an emergency and there's domestic violence involved, you can file immediately. All right, so now we're on step 3, and it says check all that apply, and it again is talking about jurisdiction. Did the grounds for divorce happen here in the state of Maryland, or did they occur outside of the state of Maryland? But we, the plaintiff and the defendant, are residents of the state of Maryland. Now, only one of you need be. Step 4 is to tell us what, if any, children are born of this marriage. If you have children that are yours, his, mine, and ours, you need only list the children you share in common, either that are biologically yours and your spouse's, or that have been adopted by you and your spouse. If your spouse has children that live with you, but that are not part of the divorce, you need not list them. If you are looking to get custody of those children, you have to file a separate complaint. Step 5, you must tell the court any other cases that are out there. Many times litigants make this next mistake. They file a custody case. They file a paternity case, and then they file a divorce case. They could do it all in one case. Again, if you consult with an attorney, you will save yourself a lot of time, effort, and needless hassle. Even if you just go to a free initial consultation, some attorneys charge $50, $75, $100, Most attorneys, I think nowadays, still have a free initial consultation. I know I do. In any event, the court needs to know any and all other case numbers. This is exceptionally relevant if there's domestic violence. If there's domestic violence, the court needs to know. Paragraphs 6, 7, and 8 talk about the children and talk about who might have information regarding this case. Relatively self-explanatory. Because the court must have jurisdiction, in paragraphs 8 and 9, we talk about who the children are living with and how long they've lived in the state of Maryland. Now, let's back up. Oh, I'm sorry, let's not back up. Let's go to paragraph 10. It asks whether you want to have shared, joint legal custody or physical custody. Aha. We run into the theory of two. There are two types of custody in the state of Maryland: legal custody and physical custody. Both are very easy to understand, but they are vastly different. I'll get you in a moment. Legal custody is the ability to make decisions for your children: what school they're going to go to, what religion they're going to practice, what doctor they're going to see. Physical custody determines two things, the power of two in the state of Maryland. Physical custody determines how often you get to see your children, and it impacts child support. Now, we'll talk about child support in a moment. It is typical for parents to share legal custody, to share the decision-making ability of the children. Many times the children reside with mom. And if mom is the primary custodian of the children, it is typical that mom will contact dad and say, this major decision is coming up. Let's discuss it. The decision is discussed. If the parties cannot come to a mutual agreement, mom, as the primary custodial parent, makes the decision. It is typical for women to have the children slightly more often than the men, mostly because the men don't ask for custody. When men do ask for custody, it is not uncommon for men to be awarded physical custody of the children or a shared environment. Now, Maryland deals with specific numbers. It's 35%. If a parent has more than 35% of the overnights, 128 days a year, I'm sorry, 128 days a year, then we have a shared physical custody environment. That happens on two occasions. One, the parties agree, and two, if they don't agree, the court awards it. That usually only happens if the parties live very close to one another, and if there's been a very close and strong bond between the parents and both children, and that this has been going on for a number of years, perhaps prior to the filing of this suit.